Judiciary and Public Safety Committee, and today's date is Wednesday, March 10th, 2021. We have three bills on our agenda today. We're going to be starting with Senator Jasinski with Senate File 82. Senator Jasinski, welcome to the committee. Why don't you begin describing your bill? And I believe you have a few author amendments as well.
Thank you, Mr. Chair. Senate File number 82, I'm pleased to be here today and have the Matsons here as well with us as testifiers. Slightly over a year ago in January, still remember the day when I heard of the incident about Officer Matson's shooting. I know many of you on the committee here as well heard that as well, and the sadness that came across us was overwhelming. What this bill does is it really underscores the risks that law enforcement officers, correction officers, prosecuting attorneys, and judges have in the normal day of their duty, especially police officers. I'll give it a quote. Every normal day, an officer may make dozens of split-second decisions or encounter multiple tense situations. Any one of these can quickly turn tragic. They have to make incredibly consequential decisions in a split second, and they have to be right every time. Peace officers know this going into the job, and we are grateful they're willing to put themselves in front of this every day. So I do have a A1 amendment that is a delete all amendment, so I'd offer the A1 amendment at this time.
Senator Jasinski offers the A1 author's amendment. All those in favor say aye.
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 Opposed? The amendment is adopted. Senator Jasinski.
Thank you, Mr. Chair. I also have an A4 amendment, which is basically just a technical correction to the A4 or to the A1 amendment. Just missed a word on one of the lines, line 30. So I would offer the A4 amendment at this time.
Senator I'm sorry, we need a member from our committee to offer those amendments.
Mr. Chair,
Senator
I move the A4 amendment to the A1 amendment.
All right, Senator Kippmeyer moves the A4 to the A1 to technical amendment, author's amendment. All those in favor say aye.
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 Opposed? The amendment is adopted. Senator Jasinski, please explain your bill.
Thank you, Mr. Chair. First of all, I'd like to go to my testifiers to testify first, and then I'd like to go to Mr. Backus, if we could, to go through the technical side, unless you'd like to have Mr. Backus go first, and then I go to the testifiers, whichever per chair.
Why don't you go first, give us a lay of the bill, and then we'll have Mr. Backus explain the more technical aspects, and then we will go to testifying.
Thank you. Thank you, Mr. Chair. What this does is increase the sentencing guidelines for someone causing great bodily harm to a police officer, a corrections officer, a prosecuting attorney, or a judge. It addresses the sentencing guidelines, increasing them to make sure that it does what it does, or will affect how the prosecutor or the perpetrator is sentenced. So I'd really like to go to Mr. Backus to explain the technicalities of what we're doing and what the bill was before and how we're changing those sentencing guidelines through my bill.
Should I continue, Mr. Chair?
He's muted, but I believe he said yes.
Okay, Mr. Chair and members. So yeah, the A1 amendment, first off, Senator Jasinski asked that I talk a little bit about the original bill. The original bill was amended the attempted murder crime and would have changed the sentencing through that crime. The A1 changes the conversation from attempted murder to first-degree assault. So what the A1 amendment does essentially is it creates two new enhanced crimes under the first-degree assault law. currently, first-degree assault, there's one crime that's when you assault somebody and you inflict great bodily harm on a person. Doesn't matter who the victim is. That's a 20-year felony. And then there's a second crime, which is where a person assaults a peace officer, a prosecuting attorney, a judge, or a correctional employee, and the person uses or attempts to use deadly force against the person. That's also a 20-year felony. That crime currently has a 10-year mandatory minimum penalty. What the bill does is, as I said, it creates these two new crimes that combines elements of the two existing crimes. The first one, and this is on line 1.22, it creates a crime for a person who assaults a peace officer, prosecuting attorney, etc., and inflicts great bodily harm upon the person. That would be a 25-year statutory maximum felony. And importantly, on page 2, under subdivision 5, that would carry a 15-year mandatory minimum prison sentence. The other new crime begins on line 1.28. It's a combination. It's where a person would assault a peace officer, correctional officer, prosecuting attorney, judge, etc., and inflict great bodily harm, and also where the assault involves the use of a dangerous weapon or the use or attempted use of deadly force. That crime carries a 30-year statutory maximum sentence and would have a 25-year mandatory minimum prison sentence. Mr. Chair, that's the bill, or that's the amendment.
I did make a bit of a procedural error when Senator Jasinski was presenting his A1 amendment. I asked him to make the motion. He cannot make the motion. So I'm going to ask Senator Kiffmeyer to move the A1 amendment as amended by the A4 amendment to put it in its proper setting.
So moved, Mr. Chair.
Thank you, Senator Kiffmeyer. Any questions on what we're doing? Evidently not. That is still an author's amendment. All those in favor say aye.
Aye.
Aye. Opposed? The amendment is adopted in its proper form before us. Senator Jasinski, would you introduce your guests?
Thank you, Mr. Chair. Yes, I would like to introduce Eric Matson and his wife, Megan, please.
Welcome to the committee. Would you? Hello. It's good to see you. Could you formally introduce yourself for the record and then proceed with your story?
Sure. My name is Eric Matson. I was an officer with the city of Waseca. On January 6th of 2020, I was gravely wounded in the line of duty.
And I am Megan Matson, Eric's wife. Well, first off, thanks for having us. We would have never thought that prior to this that we would be having to have this conversation. But we're bringing the Matson bill to your attention due to the current low sentencing guidelines. And we're here today to tell you how this tragic event has changed our lives. And Eric, would you like to tell them how your life has changed?
Every day since the incident, I find out new stuff that I can't do anymore. Such as walking on my own or walking really any distance.
So mentally, physically, we have had to find our new normal because of a repeated felon that was out on parole that should have never had the opportunity to get out. This guy has been in prison more than he has been out of prison. And our justice system needs to realize that that is an issue, that there's never going to be enough justice, but this is at least a start. These criminals need to be held accountable and not have an option for parole. If he would have been able to not have parole, this probably wouldn't have happened. 30 seconds.
Are you doing a good job?
It has changed our life completely. To have to relearn and struggle every day.
Ms. Mattson, I understand that Eric was gravely wounded at the time of the incident, and as a result, as he has said, he has limited function as a result of that encounter. I would imagine we would all agree that he's very lucky to be alive and with us today. In the circumstances around the bill, we're moving the sentences to a more severe penalty as a result of, well, as a request from you and Eric, hopefully to give a little bit more penalty to those that would attack a police officer or anyone else in a position of authority that needs to fulfill either the law or fulfill court orders, such as a correction officer or a prosecutor or a judge. And how long has it been since this episode occurred?
A year and going on 3 months.
All right. Well, we certainly are very proud to have Eric with us today. We're proud of his actions as a police officer. And
Thank you.
our condolences for putting you through this. As far as the circumstances of encountering the felon that was on parole. I'm going to hold questions for now and move on to your other testifiers, Senator Jasinski.
Thank you, Mr. Chair. Next, I would like Mr. Brian Peters of the MMPOA to give his testimony.
Director Peters, are you with us?
I am, Senator Limmer. Thank you, Chair, members of the committee. I've seen a lot of you recently, so I appreciate you putting up with me testifying on another issue. I do want to thank Senator Jasinski and County Attorney Rachel Cornelius, who I know is going to speak as well, for putting so much work into this. This has been a bipartisan bill that has gone back and forth, a lot of changes. So a lot of hard work has gone into this. You know, from my perspective and my members' perspectives, we're at a crossroads in policing. We're seeing more violence, especially against peace and police officers every single day. Just in the last 2 weeks, everybody's probably seen the event that started in Blaine and went up to Isani County, where an individual fired at police officers, striking a canine. And I do know that canines are not included in this bill, and we'll work on that later. But here's another instance where it starts from a simple shoplifting and goes to somebody shooting at police. We recently saw another case in Wadena and Sabika, where an officer was simply making a traffic stop and was shot at. One officer was shot in his bulletproof vest, and that's what saved his life. We also saw recently in Duluth, where officers were executing in a home, and canine in that instance was shot and killed. And in both instances, the officers credit that canine for saving their life. Whoever thought we'd be at this point in our society where this is becoming normal? And I don't want to normalize this issue. This is not a big city problem. This is across not only Minnesota, but the United States. And in a time where it seems like we're lowering the standards for charging somebody, we're allowing people to get out of jail sooner, I want to send a clear message to criminals that shooting at a police officer or a judge, a prosecutor, correctional officers, doing great bodily harm is not going to be tolerated for just simply doing your job. As Eric said, in his case, this was a career criminal that wasn't reformed while they were in jail or prison and shouldn't have been out on the streets, in my opinion. This is a serious problem, and I want to send a clear message that this type of behavior is not going to be tolerated. And I know that the conversations of jail reform are top of mind in a lot of these committees right now. This is different. You know, to Eric and Megan, I've said this to you before, we're so proud of you. We're so proud at the work Eric has done to be able to sit here and talk with us today. A year and 3 months ago, he couldn't even move his body. He couldn't even sit up. And he's worked extremely hard with Megan by his side. And from all of us, keep up the fight. I'm asking for bipartisan support on this bill to send a clear message to society that this behavior is not going to be tolerated. Thank you.
Thank you, Mr. Peters. Senator Jasinski, who is your next testifier?
Thank you, Mr. Chair. I would like Ms. Rachel Cornelius to go next, please.
Ms. Cornelius, would you identify yourself for the record and then continue to proceed with your testimony?
Thank you. My name is Rachel Cornelius. I'm the Waseca County Attorney. Thank you, Chair and members, for hearing us today. When I was determining charges against the defendant that shot Officer Matson and who shot also at 2 of our other officers, I was shocked by a few issues in our current laws. First, I was surprised to learn that I could only get 20 years for what the defendant did to Officer Matson. I was flabbergasted that the consequences weren't any greater for whether you shot at an officer versus actually shooting an officer, physically injuring them. In this case, of course, gravely injuring Officer Matson. He had to relearn to walk, talk, eat. He may or may not ever return to work. So those are major differences than what the law currently had allowed for, was just simply if you shoot at an officer, you would get 20 years, up to 20 years maximum. The reason we had the maximum in this case was, as was alluded to, this defendant had off the charts criminal history. The current laws, like I stated, they don't differentiate. Also, the concerns are that even if he got sentenced to that 20 years, he'd be eligible for parole after only 14 under the current laws. 14 years, of course, is just not acceptable. So once I determined that the current laws weren't acceptable, Eric and Megan and I talked, and they agreed that it was unacceptable. And they asked me what we could do. I said we needed to talk to our legislators and make changes. So, and pursue the changes and do what we could do to help. So that's why we're here. We approached Senator Jasinski, also Representative Petersburg in the House, and talked to them and their legislative teams. And we've all worked really hard on a lot of different drafts and ideas. And what can we do? What makes the most sense? And what satisfies what we're trying to do here? This bill fixes those gaps in the law. This bill allows changes for defendants who commit that great bodily harm, which is what happened to Officer Matson. And also, I like that it has a couple different levels. You have the using deadly force against an officer and committing great bodily harm, but you also have just simply assaulting an officer and committing great bodily harm. So if they just injure that officer without a deadly weapon, they still can have different consequences. This tiered approach is more appropriate. It's actually more consistent with what we have in our regular everyday assault laws. So, we have assaults 1 through 5 right now, 5 being a misdemeanor, 1 being a felony, and that's what we're amending here today or asking for bill changes today. Those different statutes have to deal with whether weapons are used and what other factors are with the level of injuries. So this really just makes a lot of sense that we would carry that over to assaults against officers. So Also, the other part that's really important in this bill is that the minimum sentences and not being eligible for parole is such an important part. Allowing a defendant out after only 14 years is quite frankly a travesty. Minimum sentences are required to ensure someone who shoots and causes great bodily harm against an officer or justice partner will be held accountable. We urge you to pass this really very much needed legislation. The current law is simply inadequate for cases involving the use of deadly force and causing great bodily harm against our law enforcement and justice partners. While increased penalties do exist for assaults against average citizens, we lack that. Prosecutors lack that tool when it comes to assaults against our justice partners and law enforcement. This legislation will enhance those punishments, those penalties. It'll bring parity to the law and give appropriate consequences for crimes. Crimes that can cause years and years of recovery for victims like Officer Mattson. So thank you for your time today. We appreciate it.
Thank you, Ms. Cornelius. That ends our testifiers. We'll open it up for questions by members. Sarah Kipmeyer.
Thank you, Mr. Chair. I've often thought before how important this is in recognizing, probably more than anything, because some people say, why do we selectively say that it's worse to do this to a police officer because it's bad to do it to anybody? I mean, it's a crime, it's a violent crime, it's horrible. And I think probably the biggest thing that in my reading about that is that when they attack a police officer or harm them, they are standing in our place. They are trying to kill the system of protection around people. And so they are that blue wall that are there on our behalf. And so when they take those shots, they're standing in our place. And so the recognition when they're attempting to do that, if we allow that or we don't deal with it in a very strong basis, then everybody else, the rest of us, are all at greater risk. Because what do we do if we don't have the police to stand there in protection for us? And so, Officer Mattson, that's the situation you were in. You did that, and the law here was for the consequences of this action in any situation is not sufficient to deter the criminals, and also for the one who did this to keep them off the streets. And there's obviously somebody in these kinds of situations that has a future out there, and it doesn't look very positive. But at least we can protect other officers and other people from that sort of violence. But the big thing is that they stand in place of us as police, defending us, because if it weren't for them, those bullets would go to us. And so thank you, Officer Mattson and Megan. And thank you, Senator Jasinski, and also to Ms. Cornelius and Mr. Peters for working on this and helping to put something stronger in place for all of us. Thank you.
Thank you, Sarah Ingebrigtsen.
Thank you, Mr. Chair. And seems like a question that probably has been answered. I'm sorry I was late. I was at a different hearing, but maybe legal counsel can get me to understand that the assault with a dangerous weapon. Do you have a definition of dangerous weapon? I think you do in statute. Has anybody asked that question on this particular bill?
We'll ask counsel, Mr. Backus.
Thank you, Mr. Chair. Members, yes, it's defined in statute in Chapter 602. Do you want me to read it or?
Yeah, please, I would like you to read it, yes.
Okay.
Unless it's real long, I mean.
Mr. Chair, it's moderately long.
You're a good reader.
Dangerous weapon means any firearm, whether loaded or unloaded, or any device designed as a weapon and capable of producing death or great bodily harm, any combustible or flammable liquid or other device or instrumentality that, in the manner it is used or intended to be used, is calculated or likely to produce death or great bodily harm, or any fire that is used to produce death or great bodily harm. And then there's a separate definition of flammable liquid, which I don't think you need to see for this one.
Ingebrigtsen.
Mr. Chair, thank you very much for that. And just one final comment. And Senator Kiffmeyer, I just want to tail end on her, what she was talking about when they start assaulting officers. They represent the community when they wear that uniform. And it isn't a personal assault, even though it may seem to be that way. It just happens to be the officer that takes the call that day is the one that unfortunately ends up on the wrong end. And I mean, they just really are. I mean, it's not lessening the crime by anybody else who's a normal citizen that doesn't wear a uniform. It just needs to be known that they are representing us all as a community. And Mr. Mattson and Mrs. Mattson, thank you so much for your indulgence to be here, and thank you to the offer for bringing this forward.
Senator Latz.
Thank you, Mr. Chairman. First of all, to the Mattsons, I'm very sorry for the situation that you're in, and I wish you the very best and continued recovery. There's nothing good that will ever come out of this this incident. Certainly, your family is going to be struggling, and you have I think our collective support and encouragement as you do so. I generally like the framework that has been put together in this bill, and I think it's appropriate to increase the maximum penalties for the distinctions that are made here in the assault statute. So I commend those who are working on this as stakeholders for coming up and working together to get this framework. I do have a couple of questions, and I'm not sure I understood completely. So maybe the county attorney could help me a little bit. What actually is the penalty, the sentence that Mr. Officer Mattson's assailant received?
So he received a 35-year sentence because he shot it. I'm sorry.
Go ahead.
Thank you, Mr. Chair. He received a 35-year sentence because he had shot at multiple officers. So he got 20 years for shooting at Officer Mattson, and then 15 years for shooting at subsequent officers that were on scene. And so that equals the 35. The way that the sentencing guidelines works currently, you can only get 15 years for a subsequent officer if there's multiple officers involved in the same shooting.
Okay.
Senator Latz.
Thank you, Mr. Chairman. And County Attorney Cornelius, does this bill change that aspect of the sentencing guidelines application in any way?
Why don't we ask counsel to weigh in on this? Mr. Backus?
Mr. Chair, and maybe Senator Latz can clarify the question. I mean, the bill does not address anything related to the attempted first-degree murder sentence.
No, Mr. Chairman, Mr. Backus, I think the question was more directly the additional years relating to there being multiple victims here. County Attorney Cornelius indicated that the additional 15 years were added because there were other officers that were shot at as well. And that was a function of the Sentencing Guidelines Commission protocols. Does this bill address that in any way?
Mr. Chair and Senator Latz, I guess I would say no. My understanding is that in the Mattson case, the defendant pled guilty to two attempted first-degree murder charges, and then received, two sentences: a 20-year sentence for one and a 15-year from the other. And then the judge chose to have them run consecutively. So nothing has changed like that. Theoretically, under the bill, a person can get multiple convictions under the new assault crimes as well and serve them consecutively. It hasn't changed that.
Okay.
Senator Latz.
Thank you, Mr. Chairman. And then what would be the new sentence were Officer Mattson's assailant to have been convicted under the new proposed statutes?
Mr. Backus?
Mr. Chair, members, it's, I guess if you're looking at the exact same fact pattern in the Mattson case, it would somewhat depend on, I guess, how they were charged and convicted. But if I understand your question, I think that the offender could get convicted of the new subdivision 4 crime, which is great bodily harm with a dangerous weapon or through the use of deadly force. That carries an automatic mandatory 25-year prison sentence. So the offender would get that, and then it would depend on what the other conviction was for. If the other conviction was for attempted first-degree murder of another person, as it was in the Mattson case, then that would carry, I believe it would be 15 years under the same set of circumstances. Then it would be up to the judge as to whether that should run consecutively. If it was run consecutively, then you have 15 plus 25, so that's 40 years as opposed to 35 years in this particular case, assuming it's the exact same fact pattern.
Mr. Chairman.
Senator Latz.
Thank you. So, in assault, I would think, and County Attorney Cornelius could confirm this for me, but I think an assault would be an easier case to prove than an attempted murder case were to go to a jury because of the different aspects of intent that are involved. Would that be correct, County Attorney Cornelius?
County Attorney Cornelius.
Thank you, Mr. Chair. Yes, that's absolutely correct. If given this case today, and if this was the current law, we would pursue the first-degree assault charges instead.
Senator Latz.
And then, Mr. Chairman, maybe this is a question either for County Attorney Cornelius or Mr. Backus. It looks like then the penalty would be longer for a first-degree assault than an attempted murder. If you're comparing convictions and the potential penalties. Is that my reading correct?
County Attorney Cornelius.
That's correct. This is the only bill that's before that bill changes that are before you at this time. There's not anything being pursued at this time for the attempted murder.
Senator Latz.
Okay, so I guess I'm a little, I understand the motivation here. I'm just a little uncertain how to handle the fact that the penalty for what would ordinarily be considered a less serious offense than attempted murder would carry with it a more serious penalty, especially when you factor in the mandatory minimums that are involved. And I'm not sure if there are other situations in the statute where that would be the current situation or not. But I guess I'm kind of asking the question. Don't know if there's any particular response that anyone could give me unless someone has some thoughts on that. Maybe Mr. Backus knows if there are other examples in the statute where we've got a less serious offense that results in a more serious penalty.
Mr. Backus.
Mr. Chair, members, I guess one thing I'd point out is, the attempted murder statute does sound like it would be more serious, and sometimes it would be, but the attempted murder statute doesn't have any requisite level of harm. So it would apply to a case where the victim is gravely wounded, as in this case, but it also could apply to a situation where there's no harm whatsoever. So it's somewhat difficult to say, like the new crimes in this bill at the very least require great bodily harm to the victim.
Okay, thank you, Mr. Chairman, Mr. Backus. That actually is very helpful for me to understand. I appreciate that clarification. Does maybe County Attorney Cornelius knows what was the basis for Officer Mattson's assailant's release from prison? The testimony indicated that but for some supposedly early release, he would not have been on the street and in a position to do this. Do you happen to know that, County Attorney Cornelius?
County Attorney Cornelius.
Thank you, Mr. Chair. Senator Latz, yes, I do know at least some minimum information on that case. He was convicted of a first-degree burglary out of a different county, and under the 2/3, 1/3 law, he was allowed to get out of prison after he had served his 2/3 of time for that particular crime. So he had served 2/3. He was out on parole when he committed this crime.
Okay, so
Senator Latz.
thank you, Mr. Chairman. So, I mean, that's helpful. It wasn't an early release based on any of the programs that are available for release shorter than the 2/3. It was a pretty standard application of the good time statute, whereby if you do not commit any infractions of the disciplinary rules while you are in custody in the prison, then you have earned by that good behavior, is the theory, you've earned the release time at your 2/3 mark rather than at some longer period of time. And if you commit disciplinary violations while you're in custody, then your time gets extended beyond the 2/3 as a consequence. So part of the reason that I raised that is because I read through at the statutes on lines 2.13 of the bill, and one of the provisions in there deals with good time, 244.04. And I'm trying to understand how that would be applied here. Is the inclusion of that provision mean that there's no good time at all for a person that gets sentenced under these provisions?
Mr. Backus?
Mr. Chair and Senator Latz, no. If you look at the language on line 2.10 to 2.14 and say you compare it to the language being stricken in lines 1.16 to 1.21, essentially what that is that's, I guess I would describe it as boilerplate language that appears in statute relating to mandatory sentences. What that language means is that essentially the offender is required to serve the 100% or is required to serve the term of imprisonment, but the term of imprisonment is 2/3. So it does not override that traditional 2/3, 1/3.
Okay, and then thank you for that, Mr. Backus. So, I mean, I guess I've got a little bit of concern about some of that. In particular, I'm wondering for 242.19 that's listed there, does that run into any Miller versus Alabama issues because it applies to juveniles and their eligibility for release, especially in combination with mandatory minimum sentences?
Mr. Backus, do you have familiarity with that case?
I do, Mr. Chair and members, except I think I'd have to mull that over more. I'm not aware of whether that's been litigated in Minnesota. It's not something I'm really prepared to be able to discuss right now.
All right. Mr. Chairman, I know that's a case that dealt with juvenile life without parole sentences. So this is kind of this is not life without parole, but it's no parole until at least 2/3 of the sentence has been served is the way I understand this. And so I'm just kind of raising the question. I don't know the answer either. Just wondering, maybe this boilerplate language at some point is going to need to be considered in that regard, in particular concerns with regard to juveniles, because the whole theory behind Miller versus Alabama is that when juveniles commit serious offenses, their brains have not developed, have not matured or fully developed at the point at which they commit the offense, and there should be extra consideration of that element and at the time of sentencing, or the ability to return and ask for a resentencing should it be appropriate. So, I mean, it sounds like that's not a provision unique to this statute, and so I'm not going to suggest that we do any changes there, but I think it is something that we might want to take a look at more broadly at some point.
Mr. Chairman.
Yes, Mr. Backus.
Yes, I certainly don't have any kind of definitive answer, but I guess, and maybe Senator Latz already knows this, but my recollection is of those statutes being cited on line 2.13 and 2.14, that they're generally statutes that in one way or another allow either for an early release, earlier than the 2/3, or some kind of discretion with the judge. And essentially that sentence basically overrides that type of early release. And again, I don't know if that adds anything to it, but I just wanted to make that clear.
Mr. Chairman, that actually highlights two of the additional points I wanted to make. One was that the parole provision that's there, which over 609.12, which overrides the commissioner's discretion under appropriate circumstances to grant parole. I think that's the statute that the Commissioner of Corrections has requested the legislature to address in seeking to create an external advisory board or decision-making panel so that the decision doesn't rest solely with the commissioner, but rather is made by or gets input from, I think it's made by several experts in criminal justice who would be able to evaluate the situation. It might be less swayed by the individual philosophies or ideologies of any particular commissioner. So I think that's something that I think is worth looking at, only because it comes up in the context of this bill because of that boilerplate language, but it kind of highlights that in a lot of our statutes has to do with minimum sentences. This bill here is all about mandating the consequence of the sentence and limiting the judge's ability to tailor any particular sentence to the circumstances of the case. And that, I guess, one might ask, I should ask, is this sort of a mandatory, or is this the mandatory sentence? And I think Mr. Backus probably understands, and County Attorney Cornelius may understand where I'm going with that, but some mandatory sentences still leave room under the sentencing guidelines for a judge to depart as long as certain standards are met. And so I should ask that question. Is this one of those kinds of sentences?
Mr. Backus?
Mr. Chair, members, this is a true mandatory minimum sentence. There's no ability for the judge to depart from this sentence.
So, thank you. Mr. Chairman, there's, we've got kind of a blended system. We define by statute what the criminal sentences could be. In many cases, we impose mandatory minimums, but then we leave room for the judge to tailor the sentence to particular circumstances. And you can't predict ahead of time necessarily what circumstances will or will not be appropriate for increasing or departing downward on sentences. And that's why there are standards set forth in the sentencing guidelines requirements for the judges to evaluate those circumstances and make those decisions. And one of those decisions relating to sentencing has to do with whether or not the type of the facts of the crime are sort of significantly different than the ordinary facts or most common facts of that kind of a crime. Is it really different enough than the fact patterns that you see for that particular crime that perhaps a sentence should be different than what is the usual sentence? And I get nervous when we don't leave some wiggle room in statute or in sentencing for a judge to take those kind of factors into account. And it's not just here, it's sort of generally with mandatory minimum sentences that I have that concern, because the mandatory minimum sentences override the sentencing grids that have been established to create a box, if you will, a maximum and a minimum range with a presumptive middle of the box number, which becomes the sentence in most cases, or pretty close, when someone gets convicted of an offense. Now we've seen that sentences vary around the state, and we've seen both in terms of years in prison and length of probation. They vary by region, they vary by race, they vary by other factors as well. So there's a value to uniformity or consistency, and there's also a value to some discretion. And I think the question is, where do you fall on that? I generally support the concept of this bill. I'm still struggling a little bit with that particular provision, a complete and unalterable overriding of a judge's ability to tailor a sentence to fit the circumstances of the case. I mean, I understand no one's going to be happy that they're even in this situation, because there's been a tragedy that has occurred. Obviously, someone's been very seriously injured. It's a law enforcement officer who puts their life on the line for all of us every day. But I'm a little nervous about removing discretion completely from the system, as if the legislature has the ability to foresee ahead of time all the nuances of any particular circumstance relating to the case. So I guess that's my concern, Mr. Chairman, but thank you for the time to ask these questions.
You're on mute, Mr. Chair.
Oh, I wanted to say it, Senator Bigham.
Oh, don't fight over me. I wanted to remind the committee we've now used up over half of the time of our committee on this one bill, and we have 2 more left. So if we run into a time spot, we will be meeting in the afternoon. In the evening. One question, Mr. Backus, doesn't the current law, subdivision 2, does that not also have a 10-year mandatory minimum? And could you explain that?
Mr. Chair, no, you're absolutely correct. Yeah, the current law, the first-degree assault of a peace officer, prosecuting attorney, et cetera, with the use of deadly force does carry a 10-year mandatory minimum. It's structured the same way as the other mandatory minimums in the bill. They were based on it. So it's a hard mandatory minimum.
All right. So we already have that in existing law. Senator Bigham.
Thank you, Mr. Chair. Officer Madsen, I often believe that officers reflect and represent everyone in the community that they serve, and the state as a community supports you and is inspired by you. Especially, I think we appreciate your fight and your grit towards your recovery, and we thank you. Thank you for your determination, and you set an example. I don't know why I'm getting emotional, but I'm going to take a different approach. I'm inspired by your wife. And I think that this bill sets that example that if something happens, that there's justice. And so that's why I'm kind of inspired by this bill and really want to help, because I think that we're having such a hard time in many of my conversations with Director Peters, recruiting retention of a very difficult job, whether it's the mental anguish that officers have. I think this shows that level of respect, and that we need everybody to represent everybody in their community and stand up for everybody in their community. And I think that's a discussion that this committee, quite honestly, needs to have more of. And this, to me, allows for a justice. And I think that all the interviews that I've seen of your wife and you have shown that you're an incredible team. And every day that you walk out there as an officer, you're part of that team in your department, but it's your family. And your family needs to know that you're taken care of, and that God forbid something happens, that the justice will be remedied. And so that's the approach I'm taking with this bill. And so I just wanted to say that.
Thank you.
Thank you, Senator Bingham. Is there any further discussion? Hearing none. Senator Ingebrigtsen, would you move the bill?
Mr. Chair, I would move Senate File 82. And I believe it's to go to
It's to go to Finance.
Finance.
Senator Ingebrigtsen moves that Senate File 82 as amended be recommended to pass and move to the Finance Committee. All those in favor, open up your microphones and signify by saying aye.
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 Aye. Opposed? The motion prevails. Before we move on, Eric and Megan, I just want to say that anyone who loves and seeks a peaceful life has to be very proud of you, of Officer Matson, and you, Megan. We know that spouses absorb a tremendous amount of stress, especially for a law enforcement officer. And you really do, the two of you are really model citizens in that profession, that shared profession, and it's got to be shared because it'll either bond you together or it'll tear you apart. And many of us will be praying for your continued recovery. And we thank you again for your service. Good luck. We'll now move on to the next. Thank you. We'll now move on to the next bill by Senator Anderson, Senate File 903.
Thank you, Mr. Chair. Appreciate the opportunity to bring an agency bill for the Bureau of Criminal Apprehension. It's comes to the legislature because of the Supreme Court jurisdiction decision-making back in April of 2020. And we have with us today from the Bureau of Criminal Apprehension, Commissioner Drew Evans, to give us some more detail on that decision. And there is a handout in your packet. Mr. Chair, do you want to have me move the bill now or wait till the end?
Why don't we wait toward the end?
Thank you much, Mr. Chair.
Do you want to go right to our testifier?
Please.
Director Evans, or Superintendent Evans, I'm sorry.
Thank you, Chair Limmer and members. My name for the record is Drew Evans. I'm the Superintendent of the Minnesota Bureau of Criminal Apprehension. And as Senator Anderson noted, this bill is before you today to address a Supreme Court decision in relation to our predatory offender registration statutes, in particular our out-of-state registrants. In April of 2020, the Supreme Court decided State v. Martin, which was an individual who was convicted of a sex crime in the state of California in 1992. They implemented their version of the predatory offender registration statute in California, and he was required to register as a offender in that state. When he moved to Minnesota, we indicated through our review process, which is in 243.166, outlining the individuals that are required to register in the state of Minnesota. What the court case did was it indicated that when you make this determination that the state of Minnesota must look at the elements of the crime in the state of California and the elements of the crime in the state of Minnesota, and if they do not align, that individual does not have to register in Minnesota. And this is true under this decision, even if the same conduct, if charged in our state under one of our statutes, would require that individual to register based on the same facts and circumstances. And so in this particular case, we found that his offense in California, being the BCA that does this analysis with the Attorney General's office, was most analogous to fourth-degree criminal sexual conduct in our state. In California, what the statute indicated there was that the individual did not had to use unlawful restraint, and where our statute said that it had to be through use of force or coercion. And because those two did not match up, the court found that this individual did not have to register. And so what this change would do is that we indicate to deal with the differences in our statutes, that we look at the fact pattern and determine whether or not it would require an individual to register in Minnesota. This does not expand registration in Minnesota. This does not expand the number of offenses. What we are trying to do is simply remedy to ensure that if an individual committed the same crime in Minnesota and was charged under our statutes that would require registration, that would require registration based on the conduct of an individual from another state, so that there is parity and equity in our registration offenses, in our registration statute in Minnesota. And so with that, Mr. Chair, I'm happy to stand for questions or provide any additional information the committee would like.
Thank you, Superintendent. Any questions for Superintendent Evans? Hearing none. Senator Anderson, do you have further testifiers?
I do not, Mr. Chair.
All right, we'll open it up for any further questions at this time. If not, we'll go right to the vote. I do not hear any further discussion. Senator Anderson, would you move the bill?
Thank you, Mr. Chair. I move that Senate File 903 be recommended to pass and sent to general orders.
Thank you, Senator Anderson. Senator Anderson moves Senate File 903 be recommended to pass and move to general orders. All those in favor signify by saying aye.
Aye.
Aye. Opposed? The motion prevails. Thank you, Senator and Superintendent.
Thank you.
I have to take a.
You're muted.
Again. Fat thumbs. I have to pause here for a technical issue behind the scenes. Hold on, please. We're looking for our next author, Senator Senjem. And so we will have to pause here until he arrives. So apparently he's presenting a bill somewhere else. But we're calling him to get on board.
Mr. Chair, I think he's a member of the Senator Rude's committee that's running at the same time as yours. So at least he was there a few minutes ago when I was there.
Our committee should take precedence.
It should. I've told him that time and again.
I believe he's on his way. I believe Senator Senjem is in the building. Senator Senjem, you have a bill in our committee that we're ready to hear. Senate File 1177.
Thank you, Mr. Chairman and members. Mr. Chairman, I have a A2 amendment to this bill to delete all. And I'd like to have that processed if I could.
Sure. Senator Johnson moves the A2 author's amendment. All those in favor say aye. Aye. Opposed? The amendment is adopted. Senator Senjem.
Thank you, Mr. Chair and members. I appreciate you hearing today the amended version of Senate Files 1177. It's in some respects a simple bill. We'll see how simple it is as we get into conversation, but it involves the roadside testing of controlled substances. It simply says that the Commissioner of Public Safety shall design, plan, and implement a pilot project to study oral fluid testing as individuals are stopped or otherwise arrested while driving for impaired offenses. And the purpose here is to judge the effectiveness of the roadside testing equipment against reality from the standpoint of a future then urine or blood test at a prescribed place. So, and beyond that, it is well, that is the essence of the bill. I mean, we've got the commissioner consulting with law enforcement, et cetera, in developing the so-called test plan. The testing samples being obtained by a certified drug recognition expert. It's just really, Mr. Chair and members, a bill that gets at, I think, State Senator Ingebrigtsen's here, probably a long-needed methodology for analyzing impaired driving that's not otherwise related to alcohol by our law enforcement community. So, Mr. Chair, I'm going to stop there, and I've got an expert witness from the Office of Traffic Safety, Mr. Mike Hansen. If you would hear him, he will perhaps get into a little bit more specificity.
Director Hansen, welcome to the committee. Would you identify yourself for the record and then proceed?
Thank you, Mr. Chairman, and thank you, Senator Senjem. Good afternoon, everybody. My name is Mike Hansen, and I have the privilege of serving as the Director for the Department of Public Safety, Office of Traffic Safety. As Senator Senjem, I think, very accurately summed up, we're proposing a study and a process to evaluate new technology that we can put in the hands of our law enforcement officers that will help them to identify drivers who are impaired by something other than alcohol. In current practice, we already have a device that officers can use at roadside to help them screen somebody who is under the influence of alcohol, and that's a preliminary breath testing instrument. And the PBTs have been around for probably 40 plus years and have been accepted as a screening device to use in the field. Today, as we fast forward 40 years from when the PBTs first came out, we are confronting a growing and significant threat on Minnesota roadways, and that is drivers who are impaired by something other than alcohol. While our alcohol arrests have kind of plateaued in that 25,000 per year number, we are seeing steady increases in the number of drug-impaired drivers that are finding their way into the backseat of squad cars across the state. So in essence, what we're asking for is the ability to obtain voluntary test samples from persons who have been lawfully arrested for driving while under the influence of something other than alcohol. And this will enable us to test the accuracy and reliability of the instruments, to test them in actual field conditions, and then to better assess what the drug-impaired driving problem really does look like on Minnesota roads, with an eye toward the future of returning to the legislature and assuming that the technology, as many other states have found, is accurate and reliable, that we can enable this tool to be used as an evidentiary, or not as an evidentiary, but as a screening device that has the same requirements, but the same limitations as the preliminary breath test does right now. Mr. Chairman, knowing that you're up against a couple of deadlines, I think I'll probably leave it at there, and I'm more than happy to stand for questions from members.
Thank you, Director. That's the only testifier we have before us, so we will open it up for questions. Senator Latz.
Thank you, Mr. Chairman. So I have I was helping behind the scenes to prepare some of the language in the amendment. I'm very pleased that we're doing this. As Mr. Hansen stated, it is long overdue to have the ability to screen at the roadside those who are suspected of driving while impaired by intoxicating or controlled substances. I think this is a good way to go about it. So I support the bill, but I just got a couple of questions about the language, some specifics about the language in the amendment, if I may.
Let's continue.
Thank you. On line 1.17, it indicates that the fluid samples must be obtained by a certified drug recognition expert. And I guess I have two questions. One is, my understanding is the term expert is not in use in the field. It's drug recognition evaluator. Because expert carries with it a different kind of connotation. And I wonder if that was intentional. And then secondly, whether or not that limitation is going to make it awfully hard to conduct the pilot project, since most law enforcement officers are not DREs. Yet everyone is out there making traffic stops and making DWI type arrests. So I wonder if that's going to unduly limit the ability of the pilot project to accomplish its purposes.
Let's ask that question first. Perhaps Director Hansen might have a comment regarding the use of the word expert versus evaluator.
Thank you, Mr. Chair. And Senator Latz, thank you for your help behind the scenes as well, crafting the language here. I believe that error may have been something I inadvertently put out there. In the days where I was involved on the law enforcement end of it, we referred to them as drug recognition experts. You are correct. The current term and the correct term is drug recognition evaluator.
Senator Latz.
So before I make a motion to amend that term, I guess we should answer my second question, which is, do we want to include that limitation in there at all? Or should any law enforcement officer be authorized to use the device in the field? So I guess that's also a question for Director Hansen.
Yeah, Director.
Mr. Chair and Senator Latz, that's a really good question. For the purposes of a pilot study, in order for us to maximize the quality control, we have about 300 DREs across the state. And I'm confident, looking at the numbers and the activity that these specially trained officers generate, that if I put enough units out there, that we will be able to get a large enough database and enough samples that we will be able to move forward with this. The eventual goal is exactly what you're asking, sir, is to put this in the hands of the everyday street cops out there. Because as much as we'd like to train everybody to be that drug recognition evaluator in the field, that's just not practical. So we want to have a good, solid, quality controlled pilot project that we can then build upon to put the tool in the hands of all of the other street officers that are out there.
Senator Latz.
Well, Mr. Chairman, with that in mind, then I will move to amend page 1, line 17, to delete the term expert and insert in its place the term evaluator.
Does everyone understand the oral amendment of Senator Latz? We'll move forward. Senator Latz moves on lines 1.17 to remove the word expert and replace it with the word evaluator. All those in favor signify by saying aye.
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 Opposed? The oral amendment is adopted. Senator Latz, any further discussion?
Yes, thank you, Mr. Chairman. A question about line 1.22. The limitation on the use of the results of this field test not being admissible in any proceeding relating to the stop or arrest. But those are two discrete legal questions that can be raised in subsequent DWI proceedings, but they don't cover all of the subsequent criminal proceedings. And it seems to me that we should extend the limitation on its use to all of the subsequent criminal proceedings arising out of the incident in which this field test was used. So I'm not sure the exact language. We could say any proceeding relating to, well, maybe council would say this is enough to cover my concern, or we could add language that's saying something like any proceeding relating to any criminal proceeding relating to incident or something to that effect.
Mr. Chair?
Mr. Backus?
One solution might be just after any on line 1.21 insert legal and then delete relating to the stop or arrest. That would certainly have a very broad, I think that would work.
Mr. Chairman, I agree, and I make that motion.
So that I can understand the oral amendment, we would simply be adding on line 1.21 after the word any, the word legal. Is that correct?
Mr. Chair, and then on line 1.21 to 1.22, delete relating to the stop or arrest.
Oh, so a period would end after legal proceeding, then period?
Mr. Chair, that's correct.
And then strike the remainder of line 121 and 22.
That's correct, Mr. Chair.
Okay, discussion on this particular oral amendment.
Mr. Chair.
Senator Ingebrigtsen.
Mr. Chair, thank you. And Senator Latz and Mr. Backus, to be clear, are you talking about the violation of a minor consumption? I know that has been an issue for many, many years whereas, I think the captain, and I always call him captain, I used to work with him years ago. When he talks about 40 years ago, that's not nearly far enough back, but when we used to
not for you, Senator Ingebrigtsen.
Arrest youth, we would arrest youth for consuming 1.32 beer, but at the same time, you couldn't arrest the individual for under the influence of marijuana in public, and that has always been a problem. Is that what this amendment addresses, Senator Latz?
Senator Latz?
And Mr. Chairman, the whole purpose of this bill is to establish the scientific validity of a preliminary screening test that could be used to detect controlled substance or intoxicating substance use in the same manner that the PBT is used for alcohol.
Sure. Good. Yeah, and it is long overdue, I might add, for sure. Thank you.
Any other questions on the amendment? Senator Anderson, your hand is up. Is it for the amendment?
I just wanted the amendment repeated.
Oh, would council repeat the oral amendment before us?
Mr. Chair, members, line 1.21, after any insert legal and delete relating to the, and on line 1.22, delete stop or arrest, so that the sentence would read, results may not be used to decide whether an arrest should be made and are not admissible in any legal proceeding.
Thank you.
I have a question, and Senator Latz, could this be seen as perhaps being overly broad in the event that an illicit substance is used and instead of just a traffic stop, the driver through a reckless or a negligent use of a vehicle violates or commits a crime under that standard? Would this bar that individual from any further legal proceeding?
Mr. Chairman, as I read it, no, it just would bar the use of that untested field test from being used in any legal proceeding.
I see. Okay.
Presumably they would gather other evidence, and other evidence would be used to pursue a criminal charge if there was enough.
All right. Is there any further discussion regarding the amendment? I do not hear any. Does everyone understand the oral amendment as presented by council? Everybody does. All those in favor of the second Latz amendment signify by saying aye. Aye.
Aye.
Opposed? The amendment is adopted. Thank you, Senator Latz.
Mr. Chairman, I have one last technical correction, I think.
All right.
If I may, Mr. Chairman, on line 1.29, the word participants, I'll ask for council's advice on this, but I think it ought to be plural possessive, so it'd be S apostrophe, not apostrophe S. But I'll stand corrected if other grammarians disagree.
Mr. Backus, give us your grammatically correct assessment.
Mr. Chair, members, I am really the last person to ask a question like that, but I would agree with Senator Latz, yes.
So it should be considered as plural. Am I getting
That's
this right?
plural possessive, I would think, yes.
Plural possessive. Now you've got me confused. Senator Latz, are you trying to remove the apostrophe?
Mr. Chairman, I'm trying to move the apostrophe to the other side of the S. So I make that motion.
All right. I hope everyone understands this amendment.
Mr. Chairman, I always got an A in grammar, so that's correct.
All right. Well,
Plural possessive.
thanks to Senator Pappas, we now are comforted by, by the change.
Now I can support my own amendment, Mr. Chairman.
Yeah, Senator Latz moves that the apostrophe found in the word participants be stricken and a new apostrophe placed after the S in participant. All those in favor signify by saying aye.
Aye.
Aye. Opposed? The amendment is adopted.
And with appreciation to Senator Higgins, Your Honor.
Yes, I was just about ready. You're calling me Your Honor now.
I'm sorry, Mr. Chairman. I'm also ready with this, Mr. Chairman.
Let's see, you are what?
Muted.
Booted. No, muted.
Mr. Chair.
That's
I'm gonna
awesome.
remember this in future bill presentations. Senator Ingebrigtsen.
Mr. Chair, I have a question. And I'm
Oh,
sorry.
wait, are we done with Senator Latz?
Yeah, whatever.
Yes, Mr. Chairman,
right.
thank you.
We'll move quickly to Senator Ingebrigtsen.
Real quickly to Mr. Hanson. Director, can you talk to me about the oral fluid, oral fluid you're going to be sampling. Tell me a little bit about that. I'm trying to get through this stuff and see where how you describe that and how it happens out on for a sample.
Director Hanson.
Mr. Chair and Senator Ingebrigtsen, basically the way that I would envision the pilot developing is, first of all, a lawful traffic stop takes place and a lawful arrest takes place for somebody for driving while under the influence of something other than alcohol. In the course of processing that individual driver for that offense, at some point, and we'll determine the most appropriate place for that to happen, the driver would be asked to voluntarily submit an oral fluid sample. And we'll get that either through a swab or perhaps through a spit sample as an example. And then that is in turn analyzed by the roadside unit. And there's a couple of maybe 3 manufacturers out there that have this technology available. And within about 5 or 6 minutes, the results should be available. And what we're going to do with those results, again, we're going to have to build that into the study because, as Senator Latz aptly pointed out, these are not going to be admissible. And as the legislation or as the language states, it's not part of that arrest decision. And so we'll find a way to separate all of that so we can still test the effectiveness of the instrument, the accuracy of the instrument, without having an undue effect on the arrest process itself. Does that answer your question?
Yes,
sir?
it does. And I do, Mr. Chair, I have one more question then. So is it quantitative? Is there going to be, do you envision some kind of a quantitative measure? That's always been the discussion when we talk about recreational marijuana, as you know, and that has always been one of the downfalls of trying to pass that legislation. I will personally be always a downfall in passing that legislation, no matter what. But it certainly is hard to enforce that when you don't have a quantitative measurement. And then you go into the CDL thing, where you have a driver's license that somebody could actually have that still in their system, marijuana in their system, up to a week down the line. And would that show a weak test then versus a plus or minus? Or talk a little about that if you have time, or otherwise certainly offline is fine too, Mr. Chair, if you don't have time.
Director Hansen.
Mr. Chair, Senator Ingerbrigtsen, that is a really great question. And literally, I could go on probably for a couple hours, as Senator Senjem can probably attest to, talking about quantitative analyses and things like that. All of the current best practices and the science, it really tends to indicate not to use those quantitative analyses. As I explained with Senator Senjem, we have to change our paradigm a little bit when we're looking at a drug-impaired driver as opposed to an alcohol-impaired driver. Alcohol is a very well-known, well-studied substance that affects human beings basically in the same way. When we talk about drugs, both legal and illegal, prescription and non-prescription, they tend to be much more individual specific. And so it comes down really to the judgment of that street officer to determine the impairment level of that person based on whatever substance that they're using. What the purpose, just like the PBT for alcohol, it confirms that it's alcohol that somebody's under the influence of. We're hoping what we'll get out of the pilot project is the oral fluid roadside test will confirm. We know that it's not alcohol, but we know it's one of these 6 or 7 categories of controlled or intoxicating substances that are out there. So the short answer to your question is no. The instrument will not be used to obtain that quantitative analysis. It's simply looking for the presence of a drug category. Now, when we get into those larger discussions about, being under the influence and quantitative amounts and things like that, that's something that probably going to have to rely on the scientists a little bit more to help guide us in that discussion.
So Mr. Chair, real quickly, so it's going to be very subjective. It will be up to the officer who's stopping this individual. There would have to be very impaired type driving over center line, maybe even onto the shoulder down in the ditch. No alcohol involved, but there'd be traces of an illegal substance, and then you could at that time charge. Is that what you envision? I think that can happen actually now.
Right, you're exactly right.
Correct.
I'm sorry, Mr. Chair. Mr. Chair, Senator Ingerbrigtsen, you're exactly right. And that's what's happening right now, roughly 2,000 times a year on Minnesota roads when an officer encounters a drug-impaired driver. The officer recognizes that somebody is impaired. They determine it's not alcohol. If they're lucky enough, they've got a drug recognition evaluator in the area that they can call in to help them assess that person's state of impairment. If they're not, they have to rely on the standardized field sobriety tests, which are good, solid, accurate determinants, and then their training and their experience. Certainly what they observed, the vehicle in motion, why it drew their attention, the physical observations of the individual, their responses to the roadside questioning that takes place, all of those things factor into that arrest decision. And so, yeah, you've described exactly what happens currently. What we want to add is one more tool in that law enforcement toolbox to confirm that it is, in fact, one of these controlled substances that is on board and impairing that individual.
Good. Thank you so much.
Thank you, Senator Ingebrigtsen. It looks like we do have no further questions, but I do have one. Perhaps Senator Senjem, I'm reading the bill and there's an exception to prosecution or a failure, or not a failure, a non-prosecution. There is an exception on lines 1.16 and 17, and there's a list of circumstances where a prosecution, I believe, could be affected, if I'm reading this correctly. And it itemizes a number of circumstances. I'm focusing on number 6 on the second page. 2.6 is the line where we itemize a Head Start bus driving. And I was wondering if someone could explain why we have earmarked a Head Start bus on that particular line.
Mr. Chair, I think you're on the, we did a delete all. I think you're on the mother.
Oh, am I on the wrong one? Oh,
You're on the mother bill.
Yes.
well, we've removed that reference. All right. Well, the bill is now in front of us. Senator Latz, would you move the bill?
I move the bill, Your Honor. I mean, Mr. Chairman, where does it go?
Let's see, that's going to go to the floor.
Wait a minute, we gotta get rid of that honor thing, your honor thing.
Hey, I don't like it either. That's usually refers to a person that's happens to have a law degree.
We could still get you for practicing law without a license, Mr. Chairman.
The bill as amended, please.
Yes.
Mr. Chairman, I move that Senate File 1177 as amended be recommended to pass and be referred to the Senate floor.
Yeah, Senator Latz moves Senate File number 1177 as amended, be recommended to pass and be sent to the floor. Hearing no further discussion, please signify, or in favor, signify by aye.
Aye.
Opposed? The motion prevails. Thank you, Senator Senjem, and members, we stand.
Mr. Chairman, Mr. Chairman,
Yes.
before we adjourn,
Yes.
I just wanted to express to you something. Is that okay?
Yes. by all means.
Okay, I wanted to express my concern. I feel like we're not hearing a balance of bills addressing all our criminal justice issues, including criminal justice reform and accountability in the system. I feel the system that we all rely on to be fair and just, I don't feel like we're getting a full picture. So I wanted to share that with you, Mr. Chairman, for your consideration.
Thank you. Thank you for the observation, Senator Pappas. As you know, first, it's a budget year. Second, and that would be our primary focus. Second, we are most likely not going to be addressing them in the first deadline. I know the House is doing some other things and piling them up as they normally do. And we will make a decision on whether we move forward on those in the second deadline. And of course, there's always next year to review policy-focused bills as well.
Well, thank you, Mr. Chairman. I do feel though there's some urgency in some of these proposals. They've been out there for a number of years now, and I think the public is really expecting us to be a little more aggressive in how we're addressing problems in the system.
All right. Thank you. Duly noted. Thank you. We stand adjourned.